They had a property across the road from a ditch that led into a creek that led into a lake, and the federal government came in and tried to destroy them for trying to build on that property. And every once in a while, the Constitution, especially because there are more conservative justices on the Supreme Court than I think have ever been since at least the late 60s, we're getting good decisions out of the court that curtail overreaching government, unconstitutional government, and corrupt government. Because in my view, when the government takes power or asserts authority in a way that's unconstitutional, and usually evidently and obviously so, that's corruption. That's stealing liberty, right? That's stealing our right to govern ourselves by, in the case of the executive branch, asserting authorities it doesn't have and hasn't been granted by the American people through Congress. And that's at the heart of this private property regulation case related to the Environmental Protection Agency. There was a law passed in the early 70s, the Clean Waters Act, and I'm doing my summary here, so I may be off by a date or two, but the Clean Waters Act essentially allows the federal government in unprecedented ways, and I think in dubious ways, given the limits of the Constitution, to ensure that the waters of the United States, the language is, are kept cleaner. And the debate has been what constitutes a water of the United States. Now, the traditional approach has been that they're navigable. That's been the approach under law and the Constitution, and indeed that was initially the way the law was interpreted, that the jurisdiction to control dumping and things into the waters was restricted to waters that people can transit. And to a degree there was expansion of that into wetlands. The thinking was they really have to be really adjacent in a contiguous way with the river or lake or whatever that is subject to federal jurisdiction. But of course that wasn't enough for the deep staters and the left-wing radicals that wanted to expand authority under this law to effectively, as the court highlights in this case, to cover virtually, as I will say here, let me see, puddles, swimming pools. Those are, wait, no, those aren't covered. They admit that maybe swimming pools aren't covered, but virtually every other so-called wetland or dry land in the United States would be covered. And in the sense covered, meaning potentially you would have to go to the EPA before you did anything substantial, and the EPA would have to decide whether you could do it or not. And you can just imagine the cost of such the process. And the case in this instance is something I think worth sharing with you, because it shows you that this government corruption isn't just like a constitutional debate. It's something substantial that affects everyday Americans. And the case here was on behalf of the Sacketts. And Justice Alito, who wrote the majority opinion, describes the issue here. And I'll describe it, I'm going to quote from it. And I encourage you, by the way, to read the opinion. It's Sackett versus the Environmental Protection Agency. We'll provide a link to it. And it's readable. I mean, Supreme Court decisions are generally designed, for the most part, sometimes they can be quite heavy in terms of law, and it's not necessarily easy to figure out, why it's important or understand why it's important. But you often see in Supreme Court opinions, especially ones about important public policy issues, that they're accessible, and the justices go out of their way to make their arguments not only accessible to the lawyers and the courts who have to interpret and apply their decisions, but also to the American people to whom they're also responsible. So Justice Alito describes the case here really in a way that I think is going to outrage you. Michael and Chantel Sackett has spent well over a decade, I think it was almost 15 years, navigating the Clean Waters Act, and their voyage has been bumpy and costly. In 2004, they purchased a small lot near Priest Lake in Bonner County, Idaho. In preparation for building a modest home, they began backfilling the property with dirt and rocks. A few months later, the EPA sent the Sacketts a compliance order informing them that their backfilling violated the Clean Water Act because their property contained protected wetlands. The EPA demanded that Sacketts immediately undertake activities to restore the site. That's a quote. Pursuant to a, quote, restoration work plan, unquote, that it provided. The order threatened the Sacketts with penalties of over $40,000 per day if they did not comply. At that time, the EPA interpreted the waters of the United States to include, quote, all waters that could affect interstate or foreign commerce, as well as wetlands adjacent to those waters. Adjacent was defined to mean not just bordering or contiguous, but also neighboring. Agency guidance instructed officials to assert jurisdiction over wetlands adjacent to non-navigable tributaries when those wetlands also had a significant nexus to a traditional navigable water. A significant nexus was said to exist when wetlands, either alone or in combination with similarly situated lands in the region, significantly affect the chemical, physical, and biological integrity of those waters. In looking for evidence of a significant nexus, field agents were told to consider a wide range of open-ended hydrological and ecological factors. According to the EPA, the wetlands on the Sacketts lot are adjacent to, in the sense they are in the same neighborhood as, what it described as an unnamed tributary on the other side of a 30-foot road. That tributary feeds into a non-navigable creek, which in turn feeds into Priest Lake, an intrastate body of water that the EPA designated as traditionally navigable. To establish a significant nexus, the EPA lumped the Sacketts lot together with the Kalispell Bay Fen, a large nearby wetland complex that the agency regarded as similarly situated. According to the EPA, these properties taken together significantly affect the ecology of Priest Lake. Therefore, the EPA concluded the Sacketts had illegally dumped soil and gravel onto the waters of the United States. So I want you to take a step back. They had a property across the road from a ditch that led into a creek that led into a lake, and the federal government came in and tried to destroy them for trying to build on that property. The Sacketts filed suit under the Administrative Procedure Act, which is a federal law that allows you to challenge procedures and regulations and such, alleging that the EPA lacked jurisdiction because any wetlands on their property were, quote, not waters of the United States. The district court initially dismissed the suit. The district court is the federal court that you first sue in, reasoning that the compliance order was not a final agency action, but this court ultimately held that the Sacketts could bring their suit under the EPA. After 7 years of additional proceedings on remand, so I want you to think about this. They lost in a district court. They went up to the Supreme Court again, and the Supreme Court said, no, they have the right to sue at this time. So it gets kicked downstairs, and it's 7 years of additional litigation. The district court, again after 7 years, entered summary judgment for the Environmental Protection Agency. The Ninth Circuit, the appellate court, affirmed, holding that the Clean Waters Act covered adjacent wetlands with a significant nexus to traditional navigable waters, and that the Sacketts lot satisfied that standard. And we granted cert to decide the proper tests for determining whether wetlands are waters of the United States. And thankfully, every justice of the Supreme Court agreed the Sacketts were right. So it's 9-0 in favor of the Sacketts on the judgment. But as to the reasons for the judgment and the subsequent precedent of the decision, the court was split 5-4. Unfortunately, Justice Kavanaugh wanted to agree with the EPA's analysis with three other liberals on the court. Not that Kavanaugh typically is a liberal, but in this case I think he was wrong. And Justice Alito wrote the majority opinion that found as follows. The Clean Waters Act, use of waters, refers only to geographical features that are described as, in ordinary parlance, as streams, oceans, rivers, and lakes, and to adjacent wetlands that are indistinguishable from those bodies of water due to a continuous surface connection. To assert jurisdiction over an adjacent wetland under the CWA, Clean Waters Act, a party must establish first that the adjacent body of water constitutes waters of the United States, i.e. a relatively permanent body of water connected to traditional interstate navigable waters, and second, that the wetland has a continuous surface connection with that water, making it difficult to determine where the water ends and the wetland begins. And that's the new law of the land. And the EPA and the left are furious that the five-justice majority ruled in favor of common sense and restricted the government's right to regulate virtually every piece of private property in the United States of America if they so chose. I mean, this was the difference between, you know, we've all been, I'm sure you've been in and can envision being on a body of water and seeing an adjacent wetland where it gets reedy and swampy and marshy, and you kind of recognize, well, that's not necessarily the river, but it's connected to the body of water that you're traversing. But for the EPA, they would, you know, go 150 miles away and try to tie the wetland there that isn't necessarily wetland, because they define wetlands to include lands that are quite dry, by the way, was connected somehow to the body of water you're on. And so the left is furious that their power grab, their effort to abuse the authorities granted to them by the American people to hijack private property and control of private property effectively, has been derailed. Now, in theory, it might be changed by congressional action. I don't think there's going to be votes to allow the EPA to expand jurisdiction over every puddle in the United States, but you know, the left has little limits as to what they consider appropriate for federal jurisdiction. But it's great news on behalf of the American people here that this decision, this 5-4 decision, has vindicated the private property rights not only of the Sacketts but every other American citizen who faces destruction from the EPA because they fill in dump dirt on a backyard that gets damp a few times a year and is you know, across the road and down, you know, and down the way from a stream that enters into a lake, or a ditch that enters into a stream that enters into a lake. I mean, that's not the way the government's supposed to work, and you shouldn't have to worry and ask the federal government for permission to exercise your private property rights the way the EPA envisioned. And thankfully, the Supreme Court came up with this common sense approach here. And of course, the left is pretending to be furious. They knew they were on thin grounds. They knew they were on thin ground here. And so they're going to be using this, and expect them to use this as another excuse to try to pack the court and destroy our constitutional system. So to remind you, when you hear court packing, think of just having Congress add new justices to the Supreme Court until they get enough justices that they like that will overturn prior decisions or install new interpretations of the Constitution that they like. And then what happens is the next party comes in, installs a bunch of new justices on top of that to further pack the court to fix the last court packing. And before you know it, you have a Supreme Court that has dozens, if not hundreds of people, and you have a Supreme Court that is as political as a congressional committee. And that's the end of the rule of law in our nation. And so that's what the left wants to do. So all decisions like this, and I'm sure upcoming decisions, will also be used as an excuse to try to end the Supreme Court as a separate institution under our constitutional system, and end the Because as you know, the separation of powers, the judicial power being separated from the legislative power, is designed to protect our liberties, right? That's why the left hates separation of powers, because they want all the powers, the executive, the legislative power, and the judicial power, to be in one entity that they can control. And they don't believe any entities that they control should be prevented from exercising any authority, whether it be judicial, legislative, or executive, whether or not the Constitution allows it, or whether or not the people voted for them to exercise that power. And even worse, the left has been advocating for lawless and dangerous and, in my view, potentially deadly. We already know that Justice Kavanaugh was almost assassinated with these illegal protests outside the homes of the justices. So you could expect more of that. Coming up soon out of the Supreme Court are going to be key decisions, I think, which are going to be quite favorable to those of us who want a colorblind constitution that will outlaw admissions policies, which should have been outlawed decades ago, that give certain races a leg up in admissions policies that are discriminatory. And the left is furious about that because they want to be able to discriminate on the basis of race so that they can, again, control our population through spoils systems and by dividing our country and separating us by making us and causing chaos and discomfort and anger, and making it easier for them to govern, because they rely on that in order to achieve their revolutionary goals. So expect vicious attacks on the Supreme Court when that happens next. And Judicial Watch has been key and persistent in trying to persuade the Supreme Court to change their position and fix the law there. And I think we're finally going to be successful, along with many others who have been laboring in the vineyards for decades, to try to restore the idea that when the law is applied, and it ought to fairly apply to all races equally and not treat some races better than others as a matter of course. So be prepared for the deluge when the left loses that one, either next week or in the weeks following. So a lot going on. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.